Welcome members to our virtual meeting and legal panel for the small property owners of San Francisco. I'm Noni Richin, the president of the board. We have your many responses to our question of the month, and they verified for us what we all knew. Vacancies are increasing, rents are dropping. So to help with our loss of rents, our friend Supervisor Dean Preston on October 5th introduced COVID-19 rent resolution and relief fund legislation. It provides for grants for small owners of up to $3,000 per month in rent relief to be dispersed by the Mayor's Office of Housing. Naturally, there are plenty of restrictions, and the money is not there yet, so don't buy your yacht with all the money you're expecting. The money will not be there unless the ballot measure to increase transfer taxes on the November through ballot is passed. So, as my Russian grandma used to say, we're gonna see. Another bright spot, a real bright spot this time, is the successful judicial decision against what we've been calling the buyout legislation. This legislation was passed some time ago, and just last week, the court stated that the ordinance, a complicated piece of work that restricted tenant buyouts, created new classes of buyouts, and contained several gotchas for us members. We all filed suit along with our other property partner groups. And our board member, Justin Goodman of Zacks, Friedman, and Patterson, was one of the principal attorneys on this response to the legislation. And we were successful. The judge said that the legislation does not stand. At the statewide level, along with the California Rental Housing Association, we're participating in a task force to stem the tide of negative information. And that is the nonstop information concerning the wave of evictions that several housing killer legislators and many members of the press spew out. We may need some help from you with stories, so stand by, and thanks for all the help that we do get from you. If you haven't had a chance yet to donate to the fight against Prop 21, there's still time. If you don't have the link, please email us at info@smallprop.org, and we'll tell you where to donate. This is really important. This is the main housing killer that we defeated a couple of years ago, and we need to do it again. So now I want to introduce to you our legal panel for this evening, and they're both from Zacks, Friedman, and Patterson, Justin Goodman and Shoshana Raphael, and they will answer the questions you've already submitted. Thank you, members. We hope to see you again soon in person. See you. Bye. Thanks.
Noni, thank you for the great introduction. Members, you sent in some great questions this month. We really appreciate it. And of course, there are always a lot of interesting new current events to talk about. So one of the first ones we wanted to discuss with you today, results of the buyout challenge. As you know, it has been rough out there for landlords lately. And right before the pandemic, San Francisco enacted an amendment to the buyout ordinance, which did a couple of things that were just very frustrating. You know, we learned to live with the previous one, but now from the start of negotiations, you could not even enter an agreement with your tenant for 30 days. And even if you settled active litigation, settled an unlawful detainer at 400 McAllister, the tenant could rescind it, even defensively if they breached the agreement for 45 more days, because that settlement agreement still had to be a buyout agreement that complied with the local regulation. So we challenged it on behalf of the small property owners, San Francisco Apartment Association, the Coalition for Better Housing, and our local realtors, as interfering with the state law litigation privilege, the ability to sue without threat of being sued just for doing it, for interference with the unlawful detainer statutes. And I think the most compelling one for our housing court judge, Judge Haynes, was that this interfered with the ability of the judicial branch to supervise settlements of its own cases. So that was the most interesting thing for Judge Haynes during oral argument. And fortunately, just last week, he entered his order on all three grounds. So it is not fully repealed quite yet. We're haggling over the form of the order and the judgment with the city attorney's office as we speak. But going forward, you'll just be able to comply with the sort of pro forma version of the buyout ordinance instead of this more onerous one. We also have some interesting proposed items of legislation coming up. Shoshana, what do you think about, I believe it's called the COVID-19 Rent Resolution and Relief Fund Ordinance?
Yeah, I think the idea is very sound. It's something that we can all kind of get behind. The idea is that for landlords who waive rent entirely for their tenants that are affected by COVID and COVID hardship and are not paying rent, that the city would reimburse them for up to 50% of the rent or up to $3,000 per unit if the tenant and the landlord both sign a declaration to that effect, that the hardship was due to COVID, that the landlord waived the rent entirely during some or all of the COVID covered period, and that they've waived this rent entirely. There's some other restrictions or rather options for small property owners, so 10 units or less, to get up to 65% of the rent, which all sounds great. It would be overseen by the mayor's office on housing and community development, with perhaps input from the rent board and other sources. That all sounds great. The trouble is there's no requirement that this fund actually be funded. It would take a separate ordinance or separate legislation from the Board of Supervisors to actually fund this this program. And although they're talking about using transfer tax funds to put into this, there's no requirement that they do that. So I think it pays a bit of excellent lip service to an issue we can all get behind. It helps tenants, it helps landlords. However, it doesn't seem like it's likely to actually do anything right now, absent some other legislation or some other funding source from the state, the federal government, or even the Board of Supervisors.
That also, so it seems like a bit of lip service, it sounds like. I also wonder if that would put small property owners at odds with the larger property owners for that upcoming ballot initiative that wants premium on transfer taxes for more expensive real property. We're also hearing anecdotally from our colleagues on the front lines who are doing more of these nuisance evictions that can go forward. While San Francisco has not yet funded landlord relief, they have not laid off a single Proposition F eviction defense attorney yet. So I guess that's where the city prioritizes its funds. I'm going to adjust my camera a bit so it doesn't look like you're taller than me. Again, these are just virtual backgrounds. Last thing I wanted to address, this is something we're calling Preston 2 colloquially, but it's the temporary tenant protections due to COVID-19. This would basically codify the mayor's moratorium that was implemented originally in March and was being extended piecemeal until the state government just enacted AB 3088, which we'll be discussing a little bit today. Basically, that state law ordinance said cities cannot extend any existing moratoria, and we intend to occupy the field during this time period that runs through January. But despite that, San Francisco appears to want to legislate that same kind of eviction moratorium, preventing the expiration of notices or the recovery of possession of a rental unit for a period, I think, that goes all the way through March, barring health and safety nuisance evictions or the Ellis Act, which the city can't regulate. So I believe this passed first reading 11-0 seems likely to pass, and I guess we will see what happens.
Okay, shall we move on to the questions?
Hit me.
All right, so the first one, here's the situation. After giving a 30-day notice, my tenant refused to allow viewings of the units to prospective tenants in mid-August to mid-September, at a time when the economy was opening back up. She claimed her attorney had told her that she did not have to allow showings during the pandemic, regardless of the COVID-19 precautions taken. She demanded an initial security deposit inspection without her being present, but refused to do a final inspection, claiming the initial inspection would serve as the final inspection, and that the unit would be in perfect condition and clean. However, she failed to return the keys until 2 days later. She also did not clean the unit as promised, so there were further delays in re-renting. So the question is, what do California and San Francisco laws have to say about this?
So I guess I'm going to start with an odd point of law. There's a part of the unlawful detainer statutes that actually allow a landlord to terminate it, or I guess the tenancy has been terminated when a tenant gives notice but then does not actually move out on time. And that would allow a landlord to proceed right to an eviction lawsuit. But first of all, those are not likely to go forward. And second, San Francisco never implemented that as a viable just cause for eviction. So while it's frustrating that she didn't give you the keys until 2 days later, and maybe you could even conceivably make an argument that that means she's holding on for another term, I wouldn't mess with that. If you got the keys eventually, then that's great. And if she is out of possession now and not a month from now, at least you have your apartment back and you can start addressing these other items I'll mention in a bit. We also, it's always scary to retake possession of a dwelling unit when you have less than 100% certainty that your tenant has vacated, means to vacate, is physically out. For instance, if you had this scenario and all of her personal property were still there and you had your own keys to get in, I would close that door, lock it back up, go away and make a phone call. We prefer to have some kind of ceremonial gesture of the passing on of possession back from the tenant to the landlord to protect you from potential liability. And in this case, she didn't do it. She didn't have a follow-up meeting with you to review her progress on addressing items in the initial inspection, but she really didn't have to. And while there was some frustration getting in to actually do the inspection in the first place, and she wasn't there to go over it with you, the shelter in place health officer's order is still in effect. And while real estate transactions are permitted, it really says, basically do not enter a property other than doing it virtually unless that's not feasible. So I don't think anything about how your tenant responded to this part of her obligations when she's about to vacate are problematic. But now you have actually let her know what the issues were. She promised it would be clean. You get there and she didn't fulfill her promise. I don't want to say that's fine, but you do have remedies here, which is your normal state law right to make deductions from the security deposit. You have 21 days to get it back to her. And if you were not able to complete any work during that 21 days, that's fine. You can give reasonable estimates and make your deductions. And if your tenant really does have a problem with that after she gets whatever's left over of the security deposit, you can just go through all those steps with her. Like, look, you weren't there with me to explain everything. I gave you the list anyway. You didn't address all the items, and this is exactly what's supposed to happen. So yeah, I would just follow the law. Understandably, this is frustrating for you, but this is one of the landlord rights that are still available even these days. Okay, so the next question asks, a year ago, I completed an owner move-in eviction in a triplex with a tenant buyout, filing all the paperwork with the rent board. As part of the owner move-in eviction, the tenant requested access to a vacant illegal in-law unit, which I denied due to the lack of certificate of occupancy. Since the owner move-in eviction, I have tried to pursue Ordinance 4314. This is the in-law legalization ordinance, the legalization of an existing unit for a different unit in the triplex that meets all of its criteria. All I need to do is pay for the permit now before beginning work. However, it appears that some of the structural work may be cost prohibitive. So the question is, can I move my brother into the illegal in-law unit as I save up for the cost of construction? And what actions should I take to minimize the risk? What legal liability could I incur? Shoshana, what do you think?
So this question leaves us with a bit of an assumption to make in order to come up with an answer. Trying to tease apart exactly what happened here. Let's take the first assumption, which is that you mean, and this person means a relative move-in eviction and not an owner move-in eviction, and if their brother already lives in this triplex, and what he's looking to do is move the brother from one unit, perhaps above, into this in-law, wherever that may be located. If that's the case, then the brother should not move into the in-law unit, not entirely because of its permitted or unpermitted status, but because he needs to stay in his relative move-in eviction unit in order to satisfy the requirements, the residency requirements of the relative move-in eviction and the ordinances surrounding that. So even though he may be able to make use of that space, he should not. Arguably, this is not a unit, or at the minimum, it is not a comparable unit for the purposes of a relative move-in eviction or an owner move-in eviction. So there's not a lot of liability there. It seems from the question there may be some concern that the evicted tenant may come back and say, hey, you gave that unit to someone else. Arguably, you didn't have an obligation, as it says in the question. There was no certificate of occupancy. You can't be required to rent something that is not permitted for use in this kind of situation, although the city will try in other kinds of situations to do just that. So the second scenario, or the second assumption, is that it was an owner move-in eviction. The owner lives in the building, and now they want to move their brother into the building as well, in addition, and make productive use of this in-law unit until it can be legalized. Yes, that's feasible, but you can't collect rent, and you shouldn't collect rent for a unit that is unpermitted, even though you're pursuing the legalization process. That's not enough to prevent liability for that. And on top of it, you would have liability to your brother. So it's really a matter of how much do you trust your family. There's a certain amount of risk involved there. But you can use that space yourself. You can use it in that way, as long as you don't collect rent and you understand that there is some amount of risk in doing that.
I might add to that also. I was a little confused by the question saying that it did an owner move-in eviction followed by a buyout. And while that's not uncommon, you serve your notice, the tenant is saying, oh, well, I think there might be problems with it, or I don't trust your good faith. I might want to hold over and defend this. And then you say, well, okay, what if we settle and I give you more than the law requires? Maybe you can stay in a bit longer. That's very common. And actually, one of the things that sometimes happens is an individual tenant can waive their personal rights to be reoffered the unit, or some other rights under the ordinance. But it's always good to keep in mind that the public constraints are not waivable. So yeah, what Shoshana is saying, the idea that, they move into one unit and then move into a different unit, or move out of that unit and rent it for more rent to somebody else, I would not get anywhere near that, even if the defendant tenant did waive those rights in a buyout agreement.
All right, next question. The situation is this: about 70% of my rental property will need to be torn down to repair damage caused by a fire originating in the neighbor's property. I think it will take about 15 to 18 months to complete, and my tenant will need to vacate during this period. The question is, can I raise the rent if they want to rent again after the house is fixed? If so, by how much?
Well, I want to start by saying that that's not the question. First, when 70% of a property will need to be torn down because of a fire, I have to imagine that there's major structural damage. The fire department was out there, maybe did an arson investigation. You had a structural engineer doing emergency shoring. It is surprising reading this that there is still a tenant in any portion of the unit. And certainly some tenants must have already been displaced. So I want to start by saying all those displaced tenants have a right to come back at their former rent as soon as repairs are completed. And this is a Rent Board Rule 1219. And while Rent Board Rule 1219 does not give you a hard and fast deadline to complete the repairs, even though some tenant attorneys like to file lawsuits if they think you're delaying, it says once they are complete, you have 30 days to do it. Now, if this tenant wasn't exited by the fire, if that part of the building, I guess, otherwise was fine and their access isn't structurally impaired, it sounds like the work on the rest of the building will require that nobody's there. And the Rent Board has or I should say the ordinance has a procedure for that as well. It's called a temporary capital improvement eviction. And you would displace the tenant. You're supposed to give them relocation assistance. You're supposed to have the work done in 90 days. And that's not feasible here. You need about a year and a half, it looks like. So you would want to immediately petition the Rent Board, let them know this is what's going on. There's no way we can have 90 days. And I believe they actually make you do serial petitions and dole them out 3 months at a time. I could be wrong about that, but you need to be diligent in making sure that that timeline has not expired, because on day 91, if you don't have the extension, you've committed an act of wrongful eviction by not offering it back to them. Now, as to the question, how much can you raise the rent? So if you're displacing anyone with a temporary capital improvement eviction, you can follow the normal temporary capital improvement procedures. If they were displaced by the fire, so this would, I guess, be the other tenants in the 70% of the building that must have been displaced already, you can only pass through those costs to them if you did not have insurance proceeds covering the repair work. Okay. Oh, and you're also probably in for at least 1.5 years of litigation with your neighbor, but we wish you the best of luck with that. Okay, Shoshana, this next question asks, what if the tenant doesn't cooperate in being at the premises to let a worker in to adjust the garden sprinkler timer, even after I've served him with a notice of entry? This tenant has not been paying rent or water, by the way, since February of 2020, and due to Presiding Judge Wong's order, it says, due to presiding judge who rejected a 3-day eviction notice. I'm not sure how to interpret that. I suppose maybe he's saying that because of some of the emergency orders, the court rejected a 3-day notice that may have been served before the pandemic and all the emergency orders. So as a result of this, we're going through horrible stress without the rental income. Question, what can be done?
So just to pick up on what Justin was saying there about the presiding judge, about Presiding Judge Wong, beyond the presiding judge of the San Francisco Superior Court, there was previously, I believe beginning in March, but has since expired, a statewide stay of all unlawful detainer litigation due to non-payment of rent and to most reasons for eviction for months. That went through the month of August and was lifted at the beginning of September, on September 1st. So regardless of the local court, there was no opportunity to enforce, a 3-day notice, even if it was what expired in February. There was no way to do that between late March and the end of August. That has since been lifted. The court is now hearing, San Francisco Superior Court is now hearing unlawful detainer matters. They're going forward with trials somewhat. Mixed results on what happens there, but it is moving forward. So that's come and gone. There is an opportunity to enforce that notice now, particularly in a case where where it's not a non-payment case due to COVID hardship. It's a non-payment, just a general non-payment case that predated COVID, the COVID closures and COVID hardship ordinances and legislation. In general, this has been superseded. That stay I was discussing was superseded by AB 3088 at the state level, which has to do with the payment of rent through the end of the year related to COVID hardship. So there may be some difficulty if they show hardship for paying rent after that 3-day notice, depending on what happened in terms of it being rejected. I'm not sure quite what that means here. If there was a lawsuit and wasn't, ended up being dismissed or something like that, where you need to serve a new notice, you may have an issue there. But on the basis of the previous notice, you could move forward. However, it's important to note that AB 38 also expanded state level retaliation, so eviction or rent increase in response to a tenant exercising their legal rights as a tenant. For example, not paying rent due to COVID hardship is now included in that. So retaliating against a tenant for not paying rent due to COVID could open you to liability for retaliation, for tenant harassment, or for wrongful eviction should they actually move out. Here, if you're not able to get entry, you could use the threat of an eviction. Refusal to allow reasonable access is a just cause for eviction under state law and under the San Francisco rent ordinance. But because this is an issue of adjusting the garden sprinkler timer and not a major repair or a life safety issue, it would be difficult in a San Francisco court to sway a jury to evict someone on that basis if you were to pursue that route as opposed to some sort of non-payment route. Perhaps the threat of an eviction would be enough, hard to say. even if you were successful in obtaining a judgment from a jury on that issue, the sheriff will not lock out tenants right now anyway. Although the stay in the court has been lifted, the sheriff is not cooperating with enforcing judgments for unlawful detainer right now, and it's very likely that the judgment will not be enforced for a while longer. If there's a health concern or some reason why they won't allow a worker in, that's a bit of a different situation. And ultimately the result, the advice, if you're going to pursue this threat of eviction, is to leave a long paper trail of being the most reasonable person in the room before even threatening eviction. Make sure to put in writing, do you have a health concern? Is there some way we can address this health concern? Why are they not allowing entry, and really being reasonable and trying to schedule around them or work it out. Offer to perhaps have workers tested, wear gloves, wear masks. The standards right now are just more stringent than usual. So it's very important to just leave a nice long paper trail, so when they come back later and say, hey, you're evicting me because I didn't pay my rent due to COVID, or you're evicting me because I didn't want to deal with this during COVID for a reasonable reason. You can say, I tried to work with you, I did everything I possibly could, I need to make this repair, and you're prohibiting me from doing that. I can't rent to you any longer. So that's
like cascades of running water, and this is the only way to stop property damage or something like that, right?
Certainly the more severe the repair, it says here that they're not paying for the water, so perhaps the landlord is incurring an additional cost because the sprinklers aren't timed correctly. That's certainly a concern, particularly as a practical matter for a landlord. And additional costs like that when a tenant's not paying, are really harmful and can be very difficult to deal with, but may not sway the court. Or in particular jury. So the worse it is, and the more you can document that and explain that to the tenant, why it's important that you make these repairs in a way that a court or a jury could understand and will see is important.
And if I could just touch on something you said that I think is so important these days, even aside from issues of eviction, we're getting better at contact tracing, certainly, but I don't have any medical expertise. I don't know how this thing is transmitted. I don't even think the experts have an abundantly clear idea, and apparently half the country doesn't think masks make a difference. So my concern here would be, if the tenant is putting up barriers because of pandemic safety concerns, unless you have a very well documented paper trail of trying to solve these problems, and if they let you in, you have shown protocols of how you're going to do it. You've asked this contractor that you're bringing in what his protocols are. You want all of this papered very well, and you want to take all these precautions, because if, God forbid, a tenant does contract COVID-19 and you were inside their dwelling within the last 14 days, I think there's some liability pointed in your direction, unfortunately.
And in addition to your own exposure, you don't want to expose yourself to COVID-19 if you don't have to, or the potential for it if you don't have to. All right, so the next question, here's the situation. I have a unit that needs drawings done for the purpose of both TIC documentation and for my broker to review for a possible sale. The tenants did not let my realtor in 3 months ago, citing concerns for the virus, and said they must remain in the apartment during the visit. What legal document can I present to them other than my lease that states I have a right to enter under certain circumstances but does not cover the virus situation? Is there anything new that I can legally do to enter?
Yeah, so we've touched on these issues in some previous questions. First, regardless of what your lease says, you have a state law statutory right to enter a dwelling unit, a rental unit, for certain stated reasons, and listing is one of them. But you balance that against the tenant's reasonable right to exclude the landlord from possession. That's what a tenancy is. It's the qualified exclusive right of possession. So now you throw the pandemic on top of it. Nothing about the pandemic says that you can't enter, but again, I would be sure I'm following all these protocols. My contractors have protocols that they're communicating with the tenants about. You invite the tenant to propose any other additional things that they might want, like little foot booty covers, so that you're not traipsing and stuff from the outside. Whatever thing that they might want to add to it, if you comply with it, they can't later say that you did something against their will or did something irresponsibly. Is there anything new? Yeah, you should be reviewing the health officer's orders. We're on Order J now. I'm not sure is that the 9th letter of the alphabet. Just came out September 30th, but it still says you can only access, or you should only access, if a virtual viewing is not feasible. So fortunately, in this pandemic, as opposed to the one a century ago, we have the technology to equip us to be able to do a lot of our jobs even virtually or remotely. And you might even offer your tenant, this would be up to your architect or your draftsman, whoever's doing your drawing, if they think that they can, give like those little laser measurement things so that the tenant can calculate the distances and they can walk around with an iPhone and do FaceTime. If it's possible to do the drawings that way, I would try to do the drawings that way. And that sounds like more expense for your architect. It sounds like more hassle for the tenant, but it also seems to resolve all of these issues, potentially only with the cost of money. So I think that would be my preference to see in this situation. Okay, the next question. My husband and I own 2 properties in San Francisco. We rented to somebody who moved his father in without asking. More recently, he informed us that his fiance is moving in October. We have not added the father or the fiance to the lease and do not plan to. We want to exit the rental market and have entertained the prospect of offering a buyout or an Ellis. Question, I'm wondering what our rights as landlords are in this situation. In a buyout or an Ellis eviction, are we responsible for paying the father and the fiance as well? His lease specifies that he is the sole tenant residing at the address. So this doesn't specifically ask, but Shoshana, what do you think about the ability to exclude subsequent occupants like this?
That's a tricky issue in San Francisco. The reality is, as a practical matter, for most purposes, because this person is aware of these occupants and has not served a 6.14 notice, that's the regulation number under the rent board regulations, or taken other steps to indicate that they don't approve of these occupants or exclude them in some way right off the bat, they've probably waived their right to do so and to object to the person who's already moved in. It is very difficult to exclude subsequent occupants. The best you can do is keep them as subsequent occupants as a practical matter. So here, in terms of the father who's already moved in, that ship has probably sailed, and now you have another tenant for some purposes, for depending on the purpose. And with regard to the fiance, it would be pretty hard to exclude this person from moving in their fiance for a myriad of reasons, not in the least due to some fair housing concerns about discrimination based on marital status. If they get married and want to move their spouse in, I would certainly not oppose that, unless there was some other health or safety reason to prevent that person from moving in. You would open yourself up to some liability for discrimination. The same for children in particular. A parent is a little bit different, but an argument could be made, but certainly for children and spouses. There is arguably something that could be done on the basis of the size of the unit and exceeding the occupancy that's allowed. But here, that doesn't seem to be the issue so much. I think really, if you're talking about a buyout, the first thing is always the same advice. Serve them pre-buyout disclosures pursuant to the buyout ordinance before you talk to them about it. Before you even say the word buyout, make sure to serve them with the pre-buyout disclosures and file the landlord declaration saying that you served those notices with the rent board. It's a short form, but it's very, very important to do that first. So in terms of who's an occupant...
I'm sorry to interrupt. If I could just editorialize this because it came up in one of my cases today. The current buyout disclosure technically states a version of the law that's no longer valid, or at least will no longer be valid shortly. So you might want to provide both that one and the previous one if you can find it online at the rent board still, or at least when it finally changes, give them the new disclosure, let them know they don't have these higher rights than they usually did. But sorry, please continue.
That's a very good point, especially as things change. There's no incentive not to send disclosures, really. and to cover yourself in that way. Better to send too many than too few, arguably. Here, when we're talking about who's a tenant and who's an occupant, for a buyout, it doesn't really matter. Ideally, this is a voluntary agreement. It's a matter of what you can negotiate with the tenants. You'd want ideally to have an agreement with everyone who is living there agreeing to leave, so that you're not left paying one person and having the father or the fiance remaining after the master tenant leaves. Although if the master tenant leaves, you have other remedies and other options available to you, but it doesn't help your buyout situation. In terms of an Ellis, as a practical matter, you should pay everyone. It's a long process. From the moment you file, it is likely at least a year until your notices expire. It's either 4 months or 1 year until your notices expire, but probably a year, plus a potential fight on the back end of that. So it's not worth jeopardizing the success of your Ellis by saving on relocation payments to potential tenants up front. So as a practical matter, they're all tenants. Really what the issue is whether they're eligible tenants. That's with a capital E, capital T. If you know about them or if they're subtenants, you're required under the rent ordinance and to pay relocation costs for an Ellis Act eviction to all eligible tenants. And eligible tenants is defined as authorized occupants. What that means is a bit of a guess. So best to be on the safe side and be a little conservative in your interpretation. And that's why I say if you know about them and you haven't taken any steps to make them unauthorized occupants, it's best to assume that they're authorized by your silence, by your waiver, and of any objection, and pay them accordingly. If you wanted them not to be tenants, that ship has kind of sailed. The nice part about serving the Ellis notices in terms of additional people moving in is that it would stop the clock on that. Anyone who moves in after the Ellis is not entitled to relocation payments. Anyone who moves in after that is going to be, if they don't move out at the end of the notice period, is not going to be a holdover tenant, but something else entirely. They don't have any right, and although they may be provided with an attorney by the city under Prop F, they're not going to have the same kind of fight that you see with an Ellis. That's a very specific kind of litigation that we get into at the end of that year that you don't want to have with as many people as could come in later on. So I guess the short answer is treat them as tenants, because it's as a practical matter, even though they're not really your direct tenants, and pay everyone.
And this is part of that theme we use a lot, which is when you get to the other end of something, be the most reasonable person at every stage of that. Could they possibly have been owed the money? Here's the money. I don't want to fight about it. It's
better to be you don't want to be penny wise and pound foolish when it comes to an Ellis. It's better to pay them an extra, a few $1,000s up front and not have to litigate, spend 10 or 20 or 30,000 litigating that issue on the back end, or maybe
it's an insurance policy.
Correct. Yeah. Great insurance policy. Okay. So the next one, I have a 3-unit rental building in the inner Sunset that was converted to condos in 2005. All units are rented and occupied. I would like to sell the occupied upper unit, which has 1 master tenant and 2 subtenants. I've given proper notice of my intention to sell. The master tenant has not responded to my inquiry about moving out voluntarily. Question: after COVID-19 restrictions are lifted, what is the best way to proceed to evict these tenants? Use the Ellis Act or use the special one-time permission to evict after condo conversion?
So first of all, I think the best solution to try first is going to be a buyout negotiation, especially if you are ready, willing, and able to use the Ellis Act. That's a great ultimatum. The Ellis Act has specific quantified rights for a certain amount of time in possession and a certain amount of statutory relocation assistance that Shoshana was just talking about. And in a buyout negotiation, you can offer them more than that, or maybe offer them more money and have them move out a little sooner so that you can sell the unit. outside the box thinking, they might even be qualified to purchase it. Interest rates have never been lower, and you might at least offer that to them because it would avoid their displacement. And again, you seem very reasonable in doing it if you have to take more coercive steps later. But looking at these two options for non-fault evictions, first of all, COVID-19 restrictions did not ever affect the Ellis Act. They have not been touched at the state law level, and San Francisco has no authority to stop them at the local level. So you can serve one of those notices right now. I will add that you had either better own all three of those condo units, or you better have the participation of the other owners, because an Ellis Act is the withdrawal of essentially all rental units at a property. I suppose if only one of them were being rented and two were owner occupied, maybe there's some wiggle room there. But there's a case out of Santa Monica called Belnez, I think Belnez v. Santa Monica. Somebody tried to withdraw only a single condo in a building, and the court rejected the ability to do that. So best idea would be to withdraw the entire thing, and with the participation of all other owners of record if you don't own the whole thing. As for using the, quote, one-time special permission to evict after condo conversion. So this is actually codified just cause under the rent ordinance. It's 37.9A9, which says that you can evict in accordance with a condominium conversion approved under the San Francisco subdivision ordinance. I have never done one of these myself. I only know of one person who has, and I actually reached out. I'll give her a shout out. Rosemarie McGinnis over at Andy Serkin's office. I asked her about it. She does a lot of subdivisions, and she said that the ability to use this 15 years later is murky at best. And I have to assume that unless this was done at the same time as conversion, at the same time that all tenants received offers to purchase and certain elderly tenants received offers to enter lifetime leases, I would assume that this would need to happen in conjunction with that process, or else you're probably not going to be successful. And again, Ellis is the non-fault eviction that isn't regulated right now. So probably that would be the better one, assuming you fit the mold in terms of ownership or participation of the other owners. Shoshana, the state statute limiting increases of no more than 10%. I think this is referring to state law AB 1482. The question is, does this limit apply to units that become voluntarily vacated by the tenant?
Okay, short question with kind of a lot to unpack. The first issue here is that this question assumes that the property is not subject to the San Francisco rent ordinance. So AB 1482, the state level law that Justin just mentioned, the Tenant Protection Act of 2019, applies at the state level, covers the whole state, but it does not apply where there is a more stringent local ordinance that was already in place. San Francisco is certainly more stringent and certainly older. So anything that is subject to the San Francisco rent ordinance is not also subject to AB 1482. So assuming that doesn't apply, and if it's San Francisco rent ordinance, then 10% is a dream. That hasn't happened since I think 1980, something like that. So that would never happen at this point. The second issue, if you're certainly not subject to the San Francisco rent ordinance, there's no vacancy control at the state level. What that means is that when a tenant moves out, for whatever reason, if it's a fault-based eviction or a voluntary thing, as the question proposed is, there's no restriction on what you can charge a new tenant. In San Francisco, we often see this under the Costa-Hawkins Act that exempts single-family homes and condos, separately alienable units, so single-family homes and condos, from those controls. However, AB 1482 has its own explicit exemption for a new tenancy. So that's Civil Code section 1947.12 subsection B exempts any new tenancy from being subject to the rent increases listed in subsection A of that code section. So it's only applicable to subsequent increases after the initial rental rate has been established. If your tenant moves out, you can set the rate to whatever someone is willing to pay for it. After that, you're subject to the increases at the state level. But speaking of Costa-Hawkins, we were discussing proposed legislation, and coming up this fall, coming up next month, is Prop 21. It's an effort to repeal the Costa-Hawkins Act. And I think Justin may have something to say about it, so I will, as the owner of the blog at costahawkins.com, you have a particular expert to speak about it.
And yeah, if you saw the video that Paul Utrecht and I prepared for the small property owners, Noni would have sent it out in early August, I believe. We go over all of the things that Proposition 21 would do. It doesn't just repeal Costa-Hawkins. It puts some very onerous burdens on landlords, and it flags forward San Francisco to impose Berkeley-style vacancy control, meaning the rents are set and it doesn't change whether or not a tenant vacates voluntarily, and it's entirely vacated. So watch that video again if you want to learn more about it. But I think the easy answer is no on 21. Go to noonprop21.org and donate. There's still time. And this would just be a disaster, but with your help, I think we can be successful in our state campaign.
All right. So the next question, if I do not have an FHA loan or any federal government loans on my property, does the moratorium still apply to my property? Is the moratorium on collecting rent still being fought in court? And are the courts siding more with the landlords or more with the tenants at this point?
Those are some great questions. So first of all, even going back to March, moratorium didn't really mean any one thing. There were regulations trying to prevent mass evictions for non-payment of rent in all branches of government at all levels of government. So the FHA or federal government loans probably is referring to the CARES Act, which I believe was enacted in March. And it would have prevented the filing of eviction lawsuits for non-payment of rent for a period of 120 days, but that expired in July. So that no longer applies. We had the mayor's moratoriums, again, the series of these executive orders that were being extended. And originally, a tenant had to provide objectively verifiable proof of non-payment, and that got relaxed to, I can't do it. So landlords really couldn't proceed at that time, although that sort of got superseded by AB 3088, so she wasn't extending them anymore. And meanwhile, what we're calling Preston 1 came online, and that said, for a period of time that is key to Governor Newsom's executive orders on authorizing certain enhanced eviction protections for non-payment of rent, a tenant can never be evicted for that rent, even when the moratorium is lifted. Now, on behalf of you guys, the small property owners, our law firm sued the city over this ordinance. And unfortunately, Judge Haynes did not agree with us. We argued that it was outside of what the Emergency Services Act at the state level authorized local governments to do. We authorized that it violated the promise of the state law unlawful detainer procedures in the summary proceeding to recover possession of a unit with that summary proceeding the tenant is not paying rent. And unfortunately, Judge Haynes seemed quite concerned about the effect that his repeal of that law could have on the displacement of tenants. He thought, therefore, that it was an authorized use of the city's police power, and he denied the petition. Also on behalf of you guys, we filed something called a writ of supersedious with the Court of Appeal, sort of like an emergency sneak peek on the appeal, a request for a stay when AB 3088 got enacted, because it really seems like that language wants to supersede local laws. And we asked the court to confirm that that was the case, and they denied it on an emergency basis. And we're no longer proceeding with the challenge. We won't be taking it to an appeal on the merits. We think it was wrongly decided at the trial court level, but maybe let's keep it at the trial court level and not have it become potentially become public law. In terms of whether or not the courts are siding more with landlords or tenants at this point, I think now, many months into the pandemic and many months into the rule of law suspended, courts are allowing things through if landlords are acting reasonably. So you'd really need to thread the needle at this point to get into court on an unlawful detainer for non-payment of rent. You would have to serve what is now under the state law a 15-day notice. that doesn't just allow curing by paying rent or quitting, but also by just providing a declaration that says I can't pay rent. And once we get to February, they'll have had to pay 25% of each month from September to January. But if you try to do it in the meantime, they'd have to put their head in the sand, ignore you. I guess you could get into court, and you would actually advance, at least in the initial stages right now, but they can retroactively redeem themselves in the court. That's part of the state law. So again, if you were thinking about filing a lawsuit right now, an eviction lawsuit, as Shoshana said, you want to be the most reasonable person in the room, and you want to be able to look the judge in the eyes and say, look, my client couldn't have done anything but be here right now, and they're the reason. But other options are available. We're proceeding with breach of contract lawsuits right now. We have a number of ejectment lawsuits going forward on different theories. That's a slower version of an unlawful detainer. So there are remedies for landlords, and come March, there are going to be expanded jurisdiction of small claims cases. They're going to remove the number per year that you can file, and they're going to remove the limit in terms of dollar amount when you're seeking this kind of thing. So that would be a low impact way to try to recover some of that money without spending a bunch on legal fees. We always appreciate the most expensive part of most transactions when it comes to this stuff. So there are definitely options available right now. Okay, coming up on the last question. This one asks, I have a two-bedroom and a two-bedroom and two-bath unit renting to a master tenant and a subtenant. Now that the subtenant is moving out, the master tenant is proposing to pay half of the monthly rent for up to 6 months until she finds a roommate. The question is, what options do I have? Do I have to agree on the reduced rent? Shoshana, what do you think?
So on taking the second question first, do I have to agree on the reduced rent? The short answer is no, absolutely not. There is no requirement that you accept less than the contract rent from a master tenant for the reason that their roommate has moved out. Your agreement is with the master tenant, not with the subtenant. And as a matter of not only state law, but definitely state law, your relationship is with the master tenant, and they are the landlord to their subtenant. So it's up to them to find another roommate, and they are liable for the entire rent while they do that. That said, we've talked a lot about COVID hardship and how that works. So what you might see is a tenant saying, this is a COVID hardship, and that's why I need reduced rent. And if that's the case, I think we've exhausted that subject a bit today, and you'll have some notions of where to begin, and being very reasonable with them and serving the correct notices that you would need to, and disclosures that you would need to for a tenant that is not paying full rent as a result of COVID. But in terms of just a roommate situation, you are absolutely not required to do that. And in fact, it would be unadvisable to accept less rent than a non-conforming rent payment that they make without taking a host of other steps to ensure that you're not permanently reducing the rent or the base rent on an ongoing basis. What we would want to avoid is accepting the lower rent, and then in 6 months when a new roommate comes in, they say, well, this is my rent now, and if you try to make it go back, you end up at the rent board, and the rent board applies whatever percentage onto that lower rent for your increases going forward. So it's a compounding problem. So not advisable to just take it wholesale and just say yes and just do this on a handshake by any stretch, and they can't make you. But with that, I think Justin had some thoughts on how to do it if you were a very, very nice person and wanted to help them.
Well, of course, our housing providers, our members are very compassionate. I think that they more often than not want to keep their valued tenants in possession and are willing during a global pandemic to make certain kinds of concessions. So if that's you, you need to be very cautious that you're not lowering the rent because of market conditions. And this is the way the rent board treats it. If it is because of market conditions, whether or not a tenant vacates, comes back in and sets a new rent, if they're just there continuously, but prices are dropping around them, so the landlord drops the price, well, according to the rent board, and I think this isn't unreasonable, that should be the new base rent, because they also could have just moved and paid that same rent for a comparable unit somewhere else. That's different than if a tenant loses their job and a landlord just wants to do a kind thing for this person they've known for years. I know you're working hard, you're looking for another job. I'm going to give you a break on rent for a little bit. So you need to have I think, a very thoroughly papered agreement that has recitals. It describes all of these things. And ideally, at least the way I like to do it, I like to have these rent forgiveness agreements be about something other than the contract itself. So for instance, let's say it's a 6-month period, the tenant's going to pay reduced rent. The agreement says, recitals, this is because you lost a subtenant. It's because you have a COVID-19 related loss of income, and that's why I'm doing it. But the rent is owed for all of those 6 periods. If you pay the amount you're proposing, I won't consider you in default for the rest. In fact, if you pay it timely by the 1st of the month for all of those 6 months, at the end, I'm going to forgive that amount. And you can even do that in conjunction with a smaller increase in the base rent if you want. And I think if you did that to reflect actual market conditions and did the default forgiveness to reflect the personalized situation of your tenant and the fact that they lost a roommate, that will give you the best chance of fighting that fight and defending your rights at the rent board if you do have to. Shoshana, unless you wanted to add something to that, I think with that, we have answered all the questions we received for October. Stay safe, everybody. We appreciate your participation. Vote in November and vote no on 21 in November.
Thanks very much.
Thank you.